Sir, I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black. We've wasted too much time with you. Yes or no?
So,
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court, putting him in. If you think you can get him to shut up, I'm not playing this game with him today. Appearances for the people versus Frank Mishaw Jr.
Good afternoon, Your Honor. Mohammed on the F people, PH 6771. Nice. You how it works. Yeah, you repeat it. That's perfect. Judge, to address order. The problem, sir?
Yeah. You're a defendant. Sit at the defendant's chair.
I'm not. I'm sorry. Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and no, you say I'm not a sovereign citizen.
All right, sir, don't speak.
Maybe I'm not phrasing that.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me, is it?
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time. The rule objections, they're preserved on the record.
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on record?
Yes.
Are you on oath to the Constitution?
Hold on, are you picking him up? That's one of the reasons I want you up here, so there's a microphone here.
Oscar, no.
Are you picking him up? Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution?
I didn't swear an oath to the Constitution.
You have
I took an oath that said I would follow the Constitution.
to not uphold the Constitution.
Yes, follow the Constitution.
So you are upholding your oath to the Constitution.
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less. Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today. May
All
I?
right, so that's a no. You don't want him to represent you?
No, he's, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make. And that, pending Your Honor's ruling on that jurisdictional issue, I have prepared for to conduct a preliminary exam.
Okay.
and could be available if he wanted to ask me to do that at the right time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record. I'm fine.
Okay.
So with that being said,
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine.
so today,
You have a jurisdictional argument you want to make?
what sir, no,
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a.
Yes or no?
Why are you forcing me to say, ask?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do. Yeah.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is this state?
District courts are legislative courts. That means you're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that,
I work under the authority of the state of Michigan.
what is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is
And it's not common law.
What-
It's statutory.
Okay, so it's statutory, that is what, civil?
No,
So what is it?
my jurisdiction is both civil.
I can't defend myself unless I have it on. Is it
My jurisdiction.
only two?
Sure, shut up. If you ask me a question, I can't answer while you're talking. My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right, so is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other, it don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan, and I are bringing the charges.
Am I injured?
Sir, sit down. Sit down. Sit down, or I will hold you in contempt.
Another threat.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call on the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, would request a mutual order of sequestration with an exception for the OIC.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name.
Your witness, yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
Did I object? What I'm supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of a probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here.
This is the probable cause hearing.
It says
All right, stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds have I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objections.
That we are having a preliminary exam when I haven't had a probable cause hearing that I did not.
They're the same thing,
It's
Mr. Michaud.
still, it's on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different day that says a preliminary.
Have you ever had a grilled
If
cheese?
it was different,
Have you ever had a grilled cheese?
if it was different, why would it have two?
Have you ever had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, having a court record for reflect, at a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud, that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I'm just trying to.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today. So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felon. Do you have any questions based on that?
At what point did I waive it? Because if this is a hearing.
You didn't waive it. There's nothing to
You would have a right to have a probable cause conference.
No.
What?
You can do that right now. Do you want to make a deal with people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still take preparation.
You want a PCC? Go on the hall. Have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? You want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this day and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to wait? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felon, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today. He ruled on his arguments, and that he preserves his right to.
He can appeal them.
As you've already said, circuit court. So he wants to sort of move forward on that defense alone. That the waiver does not preclude him from arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contact.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to.
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested.
Criminal what?
Bid bond.
Hold on.
I requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is a.
Listen, you can't tell me something and then just disagree with me.
Well, okay.
Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run. There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have the bond.
Okay, I have a bond.
Everyone
I
here
don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address, okay, so,
I'm not addressing any of that crap you
Can
got
you-
in front of you.
well, since you say you don't have a bond, can you express that in a via affidavit so I can have,
It's on the record. Order a transcript. I'm not signing anything for you.
okay. Also, I want to also address that. I sent the affidavit of fee schedules for violation of my rights.
There are no fee schedules.
Well, I gave you notice and.
Great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney,
Okay, you said that.
right? And
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
I'm not
recognize
a
any of that.
United States citizen. I am
Stop,
actually.
hold on, stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you and nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does mean,
prove it.
it should mean something
Can you
because,
prove it? Please prove
can I
it.
prove what?
Prove that I am not that I am the artificial person.
I can prove you're Frank Michaud.
Oh, faith and prayer.
I can prove,
Okay, so.
hold on, you've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And I.
You proved it for
threatening
me.
You threatening me.
But if you're not you, the threat means nothing.
It doesn't mean nothing. But
Okay.
you still threatening me and you're using it under color of law.
Okay, listen,
And first,
listen to me. Mr. Michaud,
You have more.
I've wasted too much time with you. Yes or no?
So.
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or
I
no?
object. I will address,
Answer the question.
and I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having,
And you can appeal that too. Sentence is 30 days. See you in 30. Happy to hear your objection.
due process.
Appeal me. That's why circuit court judges have jobs.
Yep.
Take him out of here.
Color of law,
I can give you more than 30 days.
30 days.
I don't think we're gonna use you, okay? The internet is the worst thing in the world for these guys. For trial on Clay versus Park Estates. Mr. Clay, you ready to roll?
Yes.
All right, counsel, your appearance for Park.
Seven, turning on the deck.
Okay. Let's get started. Any opening statement or you just want to jump into testimony? Yeah, go ahead.
I, took over that brother, my mother passed away on 5/8/24. And my brother was evicted on 10/23 of 24. And I, sold that trailer to a guy that backed out of the deal, started suing me too. I don't know if you recall that.
I don't.
But, we didn't lost. But I tried to sell it again and the park manager refused to let me sell my trailer. Because he said that other guy had any lawsuit against me. And so I went to trial or hearing and he never showed up. I got dismissed and I took the dismissal to the park manager and said, now I can sell my trailer, So I went to the second hearing to be filed. And, he didn't show up at court again. And, I took the second dismissal. He said it's checked with his legal department. And he still didn't sell for them. And then I talked to the manager that she's above the park manager, operations manager, or district manager. And she said, well, you didn't sell your trailer. We don't. But after they said yes, they said I owe $7,500. I could have sold it that month of November. The other guy backed out on the 31st of October, and I got plenty of people.
Okay, let me stop you, because this sounds like you're telling me your whole case in testimony.
Yeah.
All right, well, you understand, nothing you're saying right now is going to be used in my decision-making, because it's not evidence, it's just an opening statement. Okay, all right. Anything else is by way of opening?
Okay. Opening or reserve? Go ahead.
This is a case where the goalposts have been constantly moved. Mr. Clay filed a amended complaint April 29th of this year. We had at least one pretrial subsequent to that date. And at that time, I explicitly asked Mr. Clay whether he was going to stick with the allegations in the April 29th suit. Because those allegations superseded basically everything that he's just stated. The original lawsuit involved alleged interference with his right to sell the trailer. Claim delivery case has nothing to do with that. And Mr. Clay explicitly indicated that this was what he was going to rely.
Just to make sure in my memory, the amended complaint took it to a claim and delivery, correct? Okay, go ahead.
So anything above and beyond the allegations in the complaint, I would argue are irrelevant for this trial based on the acknowledgement Mr. Clay made in the pre-trial. Further, Your Honor, the eviction itself was completely proper. Pursuant to case number 24-6294 LT, which you also presided. A judgment of possession was entered in that case in favor of my client and against Mark Clay, who actually gave permission for his name to be signed. It was a consent judgment. That required all rent to be brought current by September 27, 2024. When the rent was not brought current, an order of eviction was submitted, which you entered on October 7, 2024. The eviction was then carried out. Now, the claim and delivery complaint claims damages for basically, I guess, the wrongful taking of certain property pursuant to the order of eviction. I would argue that Michigan case law is very clear and Michigan statutory authority is very clear that my client is immune from any damages because the items that were removed pursuant to the law of the issue.
Okay, all right, thank you. All right, ready to present your case? Okay, do you have any witnesses or are you going to testify? Okay, counsel, are you all right if he just stays where he's at after I swear him in? Are you okay if he stays there to testify instead? Yeah, and you'll let me know if you're not picking him up. He seems to be loud. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth today? All right, so give me your testimony.
Well, testimony is, I took over this trailer from me and made one look backwards.
But let's get to the point where you file a claim and delivery saying that they owe you money for property. So let's get to that.
I spoke with them and some law firm that helps people.
Okay,
They talked about claiming delivery. I have no idea about that.
okay,
And, they took my property from my trailer. They had no right to enter my trailer under Michigan law. I guess the way it is. Says they cannot damage your property. Your property stays yours. If they say they did it under Michigan law, they didn't do it under Michigan mobile home law. It says they cannot damage my property or take my property. Maybe later when different costs occurred, I had it all paid up. They just let me sell my trailer and this would have been done long ago.
okay, so what property was damaged?
Fishing tackle on my property. They loaded everything in the trailer. Into three trailers, in my mobile home, in the three trailers that was hooked into the landfill. On the 23rd of October of 2024. And they had no right to enter my trailer. They had the right to evict my brother. And, but they didn't have no right to take his property or my property because that's my trailer. That, they say that you signed an order saying they can do that, but I don't see how you can really do that.
I didn't sign an order that said they could take personal property out of the trailer and put it to the dump.
But that's what they said in a little meeting we had. The judge signed the order such that. I don't think that unless they put a fraud on the order saying that it was their trailer or something. But, yeah, that's my case about my claim.
Okay, but you understand with the claim and delivery, you have to establish value of the property and exactly what the property is and so on and so forth. Because a claim and delivery is saying, Judge, I want my stuff or I want the value for my stuff.
I got it in my filing.
In your what? I'm sorry? Your filing is not evidence. Your filing is not evidence. I make decisions at trial based on evidence. So you have to present the evidence today if you want me to consider that in my judgment. You understand what I'm saying?
I mean, but I can,
I don't know what to tell you. You've chosen to get into this arena without counsel. It's not fair for me to try your case for you and leave him to defend himself or his company. I can't help you present your case. All right, so I'm going on a limb when I tell you what you're supposed to be doing right now is establishing the items and the value for those items if you want me to give you a judgment of money for the missing items.
all right, well, I have some tools. I mean, do you want it written down, or would you like to just?
Once again, I can't tell you how to present your case to me.
I have some tools that we're missing, that we're taking out of my shed and my home. I would value them at about $7,500. It was taken, and they took my dad's flag, his military flag, which I considered that priceless. That was in a box in the house, and they took about I put it down $10,000. They took about $30,000 fishing tackle, but I used to be on
Well, my limit is $25,000.
yeah.
Right.
And then they took some furniture, some couch, and some clothing. That's what I put down there as the amount. I know.
Okay, but once again, your filings aren't part of today's record at trial. So you keep saying, I put it down there, I put it down there. You've got to talk about it today as sworn testimony.
$3,000 worth of small appliances they took out. And probably about $1,000 worth of clothes. And my dad's flag and some living furniture, which was about $1,200, I can say. That's my personal property.
All right, anything else at this time?
I was just like, literally.
Counsel?
Your Honor, defendant moves for a directed verdict based on Brown versus Real Estate Management Specialists, 2021 Court of Appeals case.
You have a copy for him.
I'm going to quote directly from that decision. Plaintiff argues that defendants operated outside the scope of the eviction because they were not entitled to enter plaintiff's home, remove her personal property, and dispose of it in a trailer. We, the Court of Appeals, disagree. The possession judgment advised plaintiff that she had to pay $3,519 by May 14, 2018, or leave the premises. It also advised that an order of immediate eviction could occur for the failure to comply, and that partial payment was insufficient to stop the eviction, which, by the way, is what the judgment provides in this case. And that we provided in Exhibit 1. It is difficult to discern how plaintiff believes that she could be compelled to leave the premises, but allow the possessions to remain. Indeed, the judgment granted possession to the plaintiff or the defendant in that case. And the order of eviction directed the court officer to restore the plaintiff to and put the plaintiff in full possession of the premises, which is exactly what the order of eviction states in this case. To state that REMS, which is the plaintiff in that case, would be granted possession of the property, obtain the right to evict a person, but would not permit the removal of the person's belongings, would deprive REMS of the use of its property. After a lease is forfeited for non-payment of rent, the landlord may obtain lawful possession and forcibly remove personal property which does not constitute a breach of the peace. There is no indication that plaintiff attempted to negotiate with counsel for REMS for a date certain to remove her belongings, despite previous negotiations. This claim of error has no merit.
What were the premises in Brown?
It's fair.
Who owned it?
It was owned by, well, it was leased to Brown, who was the plaintiff in the case. She's the one that was claiming damages for the removal of her property. REMS, the defendant in that case, was the party that obtained the order of eviction.
Okay, at one point you said REMF was plaintiff. That confused me.
But it was plaintiff in the eviction case.
I'm sorry, plaintiff in.
It was plaintiff in the eviction case. I apologize. So that's word for word quoted from the opinion. I will provide you a copy. But
He said it wasn't there.
now,
Hold on. Not your turn yet.
it's not the only case though, that provides immunity for carrying out no jurisdiction. I would also refer the court to Term Ministries versus Bank of America, also a court of appeals case decided in 2011. And the landmark case in that area is a case called Sickles, Sickales, from 2007. Barnaby versus PCI also is on point. That case is a 2015 court of appeals case. There's no question that my client and the court officer are entitled to immunity, statutory immunity, and I will cite the statute. It's MCL 600.2918 is the applicable statute.
2918.
Yes, providing for it. So, combination of all these cases together plus the statute, I would submit that my client had the absolute right to remove Mr. Clay's belongings from the home, and therefore, on that basis, my client would be entitled to the directed verdict. Further, Mr. Clay has failed to meet his obligations with respect to the claim and delivery claim. He has not provided this court with any kind of documentation relating to the value of these various items that he claims were wrongfully removed. Some of which go back more than 20 years and certainly have appreciated over the course of time. Mr. Clay provided nothing in terms of how the items were obtained, provided nothing in terms of who purchased them, what the purchase price was, and any kind of appreciation burden. So therefore, he has not met his burden with respect to claim and delivery claim either. Under either or both of those theories, my client would be entitled to a direct verdict.
Response.
In this first one, he gave me, he said that it was a lease trailer. In this site, so a lease trailer, sure they come up. Even that state said it was a gray area that let them just get bought.
Let me stop you. I took it from your explanation of ownership on the Brown case that Brown was leasing from a third party, not from REMF.
Then I don't believe that's the case,
Okay,
but I will let me clarify.
sure.
She leased the home from a private landlord. REMS was the management company.
For who?
For the-
Yeah, so she was being evicted by the owner of the trailer. That's not on point with this case. That's not on point with this case, and it's disingenuous for you to imply to the court that it is.
I disagree, Your Honor.
How do you disagree? It's a different owner of the trailer. Owners have different rights than the park owner of a lot.
Your Honor.
The person that owned the trailer Brown was living in had Brown evicted, and as part of that eviction, she lost personal property. That's the same as an eviction on an apartment or a single-family residence. There's a complete body of statutory law dealing with evictions of mobile homes that's not there.
So the termination of tenancy case, Your Honor, they would have had 90 days to sell the home. This was not a termination.
But my point is you're presenting Brown as if it's analogous to our situation here, and it's not. It's a completely different fact situation. Well, guess what? I'm wearing the black robe and I say it's not. So Brown is not in my decision-making today. So if you've got something that's analogous to this fact situation where you were evicting a trailer off the lot that you own, but you had no ownership interest in the trailer, then I'd love to see that case law.
The Turner case, Your Honor, once again, is a claim that there was lawful moving storage of personal property.
Let's start with who did the eviction and who owned the trailer. Go on.
Once again, there was a claim that there was a wrongful removal of property that was taken to a storage facility. The court held that the removal was proper.
But who owned the trailer?
It was foreclosed upon by Bank of America.
Okay, so Bank of America was the owner.
It wasn't foreclosed, I agree.
Yeah, but they owned it. At the time of the eviction, Bank of America owned title to the trailer, correct?
Yeah.
Who was evicted?
The purchaser.
By Bank of America, the owner. So once again, totally different fact situation than Clay versus Park Estates.
Finally, in Barnaby versus PCI, it also is an order of eviction. And the claim was that
Don't tell me the claim. Who was the plaintiff in the eviction?
was the landlord.
The owner of the unit.
I don't believe so, but let me.
Well, if they were the landlord, if they weren't the owner of the unit, how were they the landlord?
Because they leased the unit.
So they were acting on the auspices of the owner. I lease it from Clay. Clay rents it to Landman. That means Clay is the owner for eviction purposes.
I don't, I understand what the court is saying. I don't believe that it is separate and distinct because of the fact that you have an order of eviction.
My eviction authorizes the court officer to get a trailer off your lot, not to go in and dump all the property to the dump. Never in my tenure on the court have I said to the court officer, go ahead, take personal property out of a trailer that the plaintiff does not own and throw it away. That's not what my eviction orders are meant to do.
The eviction order, and in this case, in the case that I provided, and in all three of these court of appeals cases, instructs the court officer.
Counsel, you're not catching what I'm laying down here.
I know exactly.
Your client did not own the trailer that the eviction took place at. So all those case laws, the evicting party owned the trailer. You're talking apples and pork chops. We're not even all in the same fruit basket here. So I hope you do. I hope you appeal it. So let's talk about your other reason for the directed verdict. What statutory or court rule authority do you have that I can't take testimony alone on value?
Testimony, Your Honor, it's got to be supported.
Where's that at? I'm asking you for the court rule.
Claim the raise is 3.1. I think it's 3215.
Take your time. Sure, counsel, take your time. Mr. Clay is going to go get a drink. No, he wants a break to get a drink. Go. Just don't talk while he's out of the room.
Your Honor, the court rule is 3.105. 3105C2
Hold on a minute. Okay, I didn't know he was back yet. All right, go ahead.
requires that the value be stated.
I'm sorry, counsel, 3.105. What? Right.
3.5C2 requires that a complaint state the value of the property, which is not an admission of value. So therefore, in order to establish value, the proofs have to stand. You have estimate from Mr. Clay. You don't have any supporting documentation whatsoever. Yeah.
Okay, anything else?
Indian foundation for value, took it all.
Once again, I can't tell you how to present your case, but you don't have to have original receipts to establish value.
So,
I said, original receipts for purchase is not the only way you can establish value of an item to the court. Anything else? Okay. All right, counsel, grant your motion. Let's move on to the counterclaim.
Your Honor, as I looked at the counterclaim, the judgment was against Mark Clay. So I do not believe that George Clay would step into Mark Clay's shoes. So with that in mind, if Mark Clay decides to file a lawsuit, we will go ahead and pursue a counterclaim against Mark Clay.
I think that means you're dismissing your counterclaim. You're right. I'm sorry? Any objection to the trailer being sold?
If the trailer is titled in George Clay's name,
Who's got the title? All right. So I'm just hearing that that's the only worry they,
well, $16,000 they say that rent. And that's why they have.
okay, well, he just admitted you don't owe any rent. He just said he's letting his counterclaim go because you're not the responsible party for back rent.
See that? Okay.
That's what I just heard.
I'm not letting it.
Okay. All right.
it'll be future litigation. But I suppose if that occurs, then we'll have the issue of whether there are claims that should have been claimed here. Because maybe they have claims.
I don't like to talk about how many angels can dance on the head of the pin. So if it comes up, we'll deal with it then. All right. Questions?
Well, that, tell Parker State that I can own your rent and I can sell my friend.
The rent was for the lot.
Which has nothing to do with the trailer. Would you agree?
Doesn't have anything to do with purchase price. Home's been sitting on the lot for now several years.
Because you wouldn't let him sell it. Your client told him they couldn't sell it. So now you're telling me they can refuse to let him sell it and then say he can't sell it now because the lot has too much back rent on it? Then we're going to be back here for another claim of delivery because you've forcefully taken the trailer.
Well, I don't believe you'll be able to file our own claim of delivery. That has to be.
No, my point is you can't, on the one hand, you can't say, sure, go sell your trailer. And on the other hand, say, but you can't sell it now because there's too much money owed on the rent and somebody's got to pay us that. You can't stop him from selling the trailer and then hold him responsible for the lost time. So the man needs some direction. Are you authorized to tell him, put it up for sale and get it out of there?
The authorization to try the case based on claim delivery of the spot.
What about your family?
He just dismissed that.
Hold it back, right?
Yeah, but he just dismissed it.
Okay, but.
And I can't stop him from dismissing his case. Right. So I think what I'm hearing from him is you got to sue Park Estates because they've taken your trailer.
Okay. Still true.
Have they deprived you of its use and value?
Yes,
That's a taking.
and they have, last year, they made the mobile homes.
You got to go see a lawyer, Mr. Clay. You got to go see a lawyer. Because a lawyer would have walked out of here with a judgment against them today for claim of delivery. And I know it's throwing good money after bad, but good luck. Have a nice day.
Or the judgment about anti-IP.
Yeah, I think, Carly, we got to e-file that judgment, don't we?
Yes, Judge.
Yeah. Thank you, Mr. Lehman.
Thank you.
All right, Jamie, would you turn that TV off?
Mr. Boyd walked into court facing a Class A misdemeanor charge of deadly conduct, but this hearing ended with a sentence that gave him a major opportunity to avoid a permanent conviction. The court confirmed that the state had elected to proceed on the lesser-included misdemeanor charge, and Mr. Boyd entered a guilty plea. The judge carefully asked whether he was pleading guilty freely and voluntarily, and whether he was pleading guilty because he actually committed the offense. After confirming that he understood the documents he had signed and the consequences of the agreement, the judge explained that the deal called for 1 year of deferred probation and a $500 fine. The judge then explained the biggest benefit of the agreement. If Mr. Boyd successfully completed probation and followed every condition, he would avoid a conviction on his record, and the case would ultimately be dismissed. But there was also a serious warning. If he violated the conditions of probation, he could be brought back into court, found guilty, and face up to 1 year in county jail. So although the guilty plea sounded like the end of the case, it was actually the beginning of a 1-year test. Mr. Boyd now had an opportunity to prove that he could follow the court's rules and walk away without a conviction. The judge also made sure he understood that the agreement included a waiver of his right to appeal. After accepting the plea, the judge directed him to meet with probation so he could receive all